thank y'all for being here. This is a very important topic, and it's a topic that y'all voted on as #1 topic in the Facebook group. I put out a post a little while ago about what was the most important thing around financial literacy for this month that you all wanted to talk about, and by far, estate planning was #1. Nicole has been doing. How long have you been doing? Been an estate attorney, Nicole?
7 years.
7 years. So yeah, Nicole's 7 years in the game, lots of clients, and so I wanted to bring her here so you all have access to an actual estate attorney. Because one of the things that when I'm talking to people one-on-one, a lot of times they're like, "Well, I don't know any estate attorney." So I wanted to eliminate that excuse today, again, by bringing Nicole here. So Nicole, how did you get into estate attorney, like being an estate attorney?
Well, just something that I started doing when I was in law school, and I found it to be very important, especially to our community, because we don't do it enough.
Yeah.
And so this is one of the ways, as far as attorneys go, most attorneys get involved because they want to do good, do some good in the world. This is one of my many practices where I can do some good in the world, and that's why I love what I do.
Okay. So you said you get to do a lot of workshops and things like that. Like, what type of workshops do you do?
I do a lot of seminars with various unions, various organizations about estate planning and estate administration. It's important that people know it's important, but it's on their to-do list. Right. And when it's on their to-do list, it either means that they have enough information, they just know that it's a lot to gather to do it, or they think they know what they need to know to do it, and they really don't know, so they're afraid to get started. And it's just the idea of death that people don't want to talk about right now because it ain't happening to them right now and they don't want to think about it. So when we do estate seminars, that's exactly what we are discussing during those seminars.
And so, I mean, we do life insurance and retirement planning. And it's like the same thing. Like, people just put this stuff off forever and ever and ever until it's too late. I talked to a lady today. She was 65 years old and was just like, I screwed up. Like, I screwed up. I've been putting this off for so long. And I felt bad for her, you know what I'm saying? But at the same time, I'm like, man, you should have took care of this a long time ago. So like, in your industry, like, what do you say to people that put this stuff off forever and ever and ever?
I always say that we don't know what's going to be our future. The best way to go ahead and get started is if you look at your yearly calendar, around tax time, everybody knows there's a certain deadline for them to get all their tax financial information together. It's the same thing for estate planning. That same information you're getting for your CPA is the same information that I need to know. So it's as simple as when you're getting ready to file your tax return, just schedule an appointment and come on in or have a telephone conference so we can discuss it. It's actually not as bad as you think as far as the topics of conversations that we discuss during the consultations. So I think people just have, they're overthinking it in terms of what they will need or what they're going to be discussing. So if you're already filing your return, just go ahead and schedule a conference call.
And that's like right now, right? Yeah. So people, if you did your taxes, you probably still have that folder on your desk or on your desktop. You know where it is. And what you should do is you should book some time with Nicole and just finish the process, because this is not an annual thing, right, Nicole? I'm sure you can meet what you want once a year, but you get it done and it's done for the most part, correct?
I am all about get you in and get you out.
Yeah.
Because I know that people getting them to the table took a lot of time, and it was a process to get here. So my goal is to get you in, get you out, make sure you understand everything, and so that you don't have to look back at it again. If you end up doing that, great. If you want to schedule a yearly consult, great. I mean, one of the big things that we push is our consultations are free.
Okay.
But let me repeat that. It's free. There is absolutely no reason. It's free. And so there's like no reason why you can't call and just schedule a consult. None whatsoever. Now, if you have something specific you want to discuss in terms of me reviewing certain things that you have, we can discuss what price point will be for that. But having a general discussion, figuring out what you need, what my advice would be for certain documents that you may want to get, pricing, and what your goals are, all that is free. A lot of the times people have certain people they're concerned about in their estate plan. We discuss that. We discuss things that they heard on the internet or from friends. I mean, it's basically a brainstorming conversation. So.
Okay. I want to reel it back just a little bit, because some people, and I got this question in the group, some people don't even know what estate planning is. If you could break down estate planning in a generic way for us, like, what would you say?
Okay, so estate planning is planning for your lifetime in the event that you become incapacitated, making sure you have documents to ensure that someone can make decisions, whether it be for financial reasons or for health decisions. and also planning for when you pass away, and making sure that you have someone designated as your personal representative or executor, and beneficiaries who you wish to inherit from you. So when I look at estate planning, I look at it as documentation. I also look at it as going over what you currently have as far as not only documents, like if you don't have an estate plan as far as a last will and testament, a financial power of attorney, or a medical advance directive, I'm looking at the title you have on everything. Whose names are on your home, whose names are on your bank account, what about beneficiary designations? All of that is part of your estate plan as well.
So I'm glad you said that, because a lot of times when people talk about estate plan, they're thinking about when they pass, but a lot of this stuff happens for when you're living too, right?
Yeah, I get a lot of calls of I just want to come and get a will. And then when I ask, well, do you have a financial power of attorney or a health directive? And they're like, no. So, well, let's talk about everything, because we don't know that you'll necessarily pass away. You know, what if you get sick first? What if you get dementia? I mean, right now we're dealing with the pandemic. So there's COVID. You know, so I always say it's best to plan for anything and everything, as opposed to just planning what you think is going to happen.
Right. And so what are some of the most common mistakes that you see people make when it comes to estate planning?
Oh, wow. Okay. There's a few of them. Where shall I begin? The top on my list is when I have parents who would like to name children, or title their assets with their children. So I get the call, hey, Nicole, you know, instead of me getting a will and stuff, I can just put the kids' names to the deed of my house. I get that a lot. I get that so much, or so often, that I actually wrote a whole article on our website about it and why not to do that. One of the big things that
why not to do it though? Why not to do it?
I'll tell you. So one of the big things people don't think about is they have their mindset on the goal of making sure that they don't have to go through probate. Like, I heard all these crazy stories. I don't want to have to go through it. Let me just add the kid's name on the deed to the house so that when I die, it automatically goes to them, and then that's it. Well, what happens is when you're doing that during your lifetime, say you want to sell your house, you have to get your kids to sign off on that. If your kids have any creditors, then there's a potential for any liens to your home. If your children are married and end up getting a divorce, that home is also part of their divorce proceedings because they own or have an ownership interest in it. In addition to that, it's more so like if you end up going into like a nursing home or something at some point, there could be an issue depending on when you decided to have their name added onto the deed and when you go into a nursing home. I find that there are financial reasons not to do that during your lifetime. Is actually better for your children to inherit from you than to be added on to the deed to your house. So that's my general, like, why not to do that. There are some instances where that may make sense, but for the most part, it doesn't make sense. There was even a Judge Judy case about that very thing.
Not Judge Judy.
Yeah, what? It was Judge Judy. And the mother thought that she was going to die. She wanted to make it easier. She did that, and she didn't die. And she was like, okay, well, now I feel uncomfortable because you're on the title to my deed, and we don't get along now. And the daughter was not giving it up. And there's nothing that Judge Judy could do. So don't do it.
She was like, you would do it.
So that's one of the top mistakes. The other top mistake that I find more often than not is people drafting their own estate planning documents. Everyone always thinks that they are better at doing it themselves. It's always, and sometimes a financial reason why you don't want to have an attorney involved. But I always say it pays to play. And if you're going to take the time to actually prepare these documents, you actually want to make sure that it works out in your favor. Once you're gone, you're gone. You're not going to know if it worked out or not. So I wouldn't gamble with that. You know, if I was, let's say if I was going through divorce, I wouldn't represent myself. I would get an attorney. There are certain things that I would not do, even though I'm fully capable of doing it because I have a license. That I wouldn't do because that's not my go-to thing. I don't know anything about it. So I tend to say, if you don't know what you're doing, you should probably hand it off to the experts in that field to help you with that. I mean, that is our job. Whenever there's a concern about paying an attorney to get estate planning documents, what I always say is, you're not paying for the documents. So let's just get that on out. You're not paying for a will. You're not paying for an advance directive. You're not paying for a financial power of attorney. What you're paying for is for the knowledge.
Okay.
So when they say my price point is this, the price point is that because it's based on the attorney that you're going to and what information they're going to be able to provide based on their experience.
Right.
There's no, I would say, when I'm looking at the clients who end up trying to do it on their own, there's not like a certain, what that certain client that looks like. I've seen people who are millionaires try to draft their own will and it not work out because I've handled their estates, made a lot of money from doing that. I've also found that people who really don't have much do it, and then it ends up costing them as well. So whether you think it's going to cost you or not, the idea is if you decide you want to do it on your own and you have not sought any legal advice, that you may be costing yourself anyway, because it could be something where you made a mistake in what you're trying to say, or people don't understand what you're even trying to say in your documents. And so when attorneys do end up getting involved when you're gone and when you've passed away, end up costing more money.
Got it.
So it's just easier to have an attorney do it from the get-go, because it will save you money in the future. And
again, having it done it's not a whole lot of paperwork outside of what you will use for your taxes, right? Just so people aren't intimidated.
Exactly.
Okay. Another one that you brought up to me that I always talk about now is not putting little kids as beneficiaries on important stuff. Like I know you just said the whole thing about the deed and stuff, but that's slightly different.
Yes, that's a good one.
Because that's something that is very, very common.
Very common. That's why when we do our estate planning consultations, I look at everything. I'm not just looking at, oh, you want certain documents. I want to see what you have. So I do ask for confirmation on the beneficiaries you designated for whether life insurance or retirement assets. When it comes to minor children, they can't inherit property outright. So, I can't write my 5-year-old a check. What bank account do they have in their name? None. So with that being said, a lot of people fill out these beneficiary designation forms, and the financial institution will receive the form. Some are really great at kicking it back and saying, no, you need to make changes. We can't accept this form. Some will say, most will say, okay, I'll accept it. And I'll just worry about it later when you're gone. So what that looks like is when you pass away and a minor is to inherit whatever that property is, the parent or guardian of that minor will have to go to court to get a court order in order to receive that inheritance. So it sounds crazy because people are like, well, why do I go to court? If my child's supposed to receive something, I'll just show a birth certificate. There are many people out here with names on birth certificates who did not have parental rights. So the court needs to be able to determine that, and they will only accept a court order in order for you to receive the asset. That particular process is called a guardianship. So we charge $2,500 just to get the paperwork done. So I always say it's cheaper when you're coming in for the free consult and you're getting your estate planning done, is to let us advise you, hey, just make this change. And we can tell you what to do as far as what beneficiary designation you should say, what is the language that you should use. We can definitely give you advice on that throughout the process. But the only way that you can do that is through getting estate planning documents. You can't just, say, I want to put it into the name of so-and-so. Some people also, what they do is, in order to circumvent that, here's another way of, let me just go around the fact that I need to pay for estate planning documents. Let me put it into my sister's name and she'll take care of it, because she'll make sure the kids get it.
That's very common. Actually.
Yes.
I get that all the time. When people beneficiary, I put it in my cousin's name, and my cousin she know better.
Right. Does she? I don't know. I'm not so quite certain. I don't know your cousin. I'm sure you know her or him very well. And I'm sure you trust that person very well. I am the person that looks at all the negatives of a situation, because that's my job. Once you designate a benefit designation, that's it. There's no contingencies on that. Once they get the check, they could do whatever they want to do with it. So let's not try to think of all the ways we can get around just coming in and getting the documents done. If you do it the right way, you don't have to worry about trying to circumvent the system. It works if you want to pay for it.
Right. Okay. No, that's a good one. I mean, and I've seen it on the other side where I've sat next to people and they're like, well, yeah, my mom, she put me as beneficiary on this thing, and I'm gonna give it to such and such. And then when the money come in and it's like 100,000 sitting in their account, they're like, well, I mean, I deserve at least, and I've sat with these people like, that's what we do. Like, we got to give them the check. And
I gotta think about it. Like, what did I do?
They're like, well, I'm sitting there like, now, you sat with me a year ago and we had this conversation, and they you switching it up, and I'm just like, dang, but the money wasn't in the account at that time. And so
a million ways to try to make it work.
Right.
I can think of all the ways where I feel right now that person should be grateful that I did.
And that's how it goes. And I'm sitting there, and these are good-hearted people too. And I'm looking at them just compromise their integrity. I'm like, I hear you, That's not what you said a year ago.
It happens. Another thing to think about too is depending on the asset for which you are naming these, circumventing the system and putting all these other people to receive it on behalf of any minor children. You also have to think about the tax consequences, because I've had this happen as
Oh, good.
well.
I'm glad you brought that up.
Because there are certain assets that will receive income from that. The person who ends up receiving that inheritance will be taxed on that, because the IRS only sees their tax identification information in the system. They don't see that they gave it to somebody else after they got it. So you're putting the burden on that person to receive this inheritance, and that also includes any tax liabilities. And the person who ends up swooping in to receive it later on the back end has no tax consequences whatsoever. So there is a trickle-down effect that can happen depending on the assets that the beneficiary is named on.
Okay, that's a good point. One other thing that comes up a lot, because I'm gonna ask all the common questions. I know we have some questions in the chat. One other question: what's the difference between a will and a trust?
Okay, so a last will and testament is a document that is used if your estate is going to probate. So probate means that anything in your name solely with no beneficiary designation. Okay. So at some point in your life, whether if you're married and you have joint assets, somebody's name is going to be left on there. So one person dies, it may go to the next person, but somebody's name is going to be left. That person will have a last will and testament. If they have a last will and testament by itself, then it goes through that probate process, which the court oversees, and they are making sure that the language in the will is followed to ensure that the beneficiaries of that will receive their inheritance. And the alternative, some people get what's called a revocable living trust, which is a document you can use during your lifetime. I like to call it a merge of like a power of attorney and a last will and testament. The same information you put in a power of attorney form saying, I want to designate this person to handle the financial affairs of anything named in this trust. And if I go to page 5, if I were to pass away, any assets named in this trust should go to XYZ, same information you put in a will. This particular document allows you to bypass probate, meaning you don't go through probate so long as there are assets that are already titled under the name of the trust. So for the Nicole Slaughter Trust, if I have a trust agreement, I would be retitling my bank account, my house, whatever assets I want the trust to own, so that if something happens to me, that trust agreement dictates what happens and who gets what of that, of those assets. So it's a way to bypass probate if you have a revocable living trust. It is more expensive. There's also a little bit of legwork, because it's not just getting the document. You have to go through the legwork of retitling assets, but it's beneficial to the people who feel like it's important to them to bypass probate. I generally would recommend that type of document in the instance that I have someone who has like multiple real properties in different states. So for example, if I have a house in Maryland, but I also have a house in maybe New York or Florida or wherever, if you know this, and you maybe don't know this, because you can't pick up a house and move it. If I were to die, then every state where I own my property have to open up a probate.
Okay.
So some people are like, no, because that's a lot of attorneys involved, because it's different states. There's a lot of fees involved in that. If you have a trust, the trust could own all those properties no matter where it's located, as long as the trust owns that. If I die, go to page 5. There's no court getting involved.
Okay.
You just follow the document. So it is more expensive, but the difference between the two is, one, you're able to use now during your lifetime, and also when you pass away and there's no court involvement if you do it right. The alternative is the will, where you only use when you pass away, and it does go through probate.
Okay, that's a good point. I didn't know that. That's a good point. So a will goes through probate.
Yes.
Did not know that. Did not know that. Okay, so we have some questions in the chat. I'm gonna address those first, and I'm gonna open it up for live questions. So one question for Pamela Chapman is, can you explain a living trust?
Okay. I'm assuming you're talking about a revocable living trust, which we
let's
just discussed.
Are you in here, Pam? If you're in here, unmute yourself and just ask the question.
Yes, I think she just explained it.
Okay.
Thank you.
That's the question you had?
Yes.
Okay. All right.
Thank you.
The next question is from Valencia. Valencia says, can you touch on a special needs trust?
Okay, so a special needs trust is a vehicle that allows for any beneficiary who is receiving public benefits to receive an inheritance without making them ineligible for that public benefit. So let me give you an example. If I have a beneficiary, let's say I have a minor child who is receiving SSI benefits because they're disabled. SSI is a public benefit for which you have to only have a certain amount of assets. So if I give an inheritance to that person, say I give them an inheritance of $100,000 cash, that amount of money would probably make them, definitely make them ineligible for their SSI benefits. So if you have a beneficiary who you would like to give to, but they're on this public benefit, a way to protect their eligibility is to get a special needs trust. And there are other type of mechanisms or vehicles in order to allow a beneficiary to receive an inheritance outside of a special needs trust. And that is what I would say when you want to come into a consultation with me, so we can figure out confirming that that is a necessity. Because some people do receive disability benefits, but it's not a public benefit where they're worried about financial eligibility. Like they may not have a financial eligibility requirement. And so we want to make sure that you're planning for the right reason, that you're not spending any extra money you don't have to. And then if that is the case, then we can provide many options, including a special needs trust.
Wow, I've had that question asked. I've seen that question before. Like another client of mine asked that same question. I'll introduce you to her too. Valencia, do you have any further questions on that? Did that answer your question?
Yes, it did, and I need to make an appointment with her.
Okay, yeah, we'll get that. We'll get all that. We'll get all that for you in a second. The next question is from Ida. Ida says, to avoid inheritance taxes, can you pass on a property while living? I don't know what that means. Do you understand that?
Yes, I do. Okay, so when someone passes away, there's a number of different taxes that we want to look out for. And so I'm gonna break down the taxes to you, but this will also answer Ida's question. Inheritance tax is one of them. Inheritance tax is in the state of Maryland, where it's based on your relationship with the person who's passed away. So if you are a niece, nephew, cousin, friend, corporation, you are going to be assessed inheritance tax just based on the fact that that is your relationship to the person who's passed away. If you are a parent, a sibling, a child, grandparent, spouse, you are exempt. So if you're giving to any of those people, we can ignore this part of the conversation. But if you want to get to someone outside of that, again, niece, nephew, cousin, friend, corporation, they'll be taxed 10% on the value of whatever that you end up providing to them in your last will and testament. You can't avoid that because it's based on relationship. You could give to them in a beneficial designation. There are register of wills. When someone passes away, they ask these questions. Are there any assets that are not in this will, that are not going through probate because they've been designated to a beneficiary? Maybe they're joint on account or whatever. Are they going to people who are or who are not exempt from an inheritance tax? We have to tell them that. And the register of wills will determine whether they're going to get a bill or not. So when people do their estate plan and they are thinking about giving to a niece, nephew, cousin, friend, corporation, what we do is we advise them that this could happen, or this, this will happen. And sometimes it's up for discussion, because say I want to give a car to my niece or nephew. If the car is worth $14,000, I have to make sure they have $1,400 cash.
Right.
So my inheritance to them could be not a good thing, could be a burden. Right. So I have to make sure either I'm giving them some money somewhere else, they can have the cash to pay for the inheritance tax. Whoever's getting cash, they may say, well, they're getting cash anyway, they'll figure it out, Some people say, well, let me give it to someone who's exempt, like my sister or brother, so that they can give it to my niece or nephew. And that person's not exempt at that point. They are exempt. I'm sorry. The sister or brother is exempt from inheritance tax. So some people change their mind and not give it to the niece or nephew and give it to the sister or brother because they're exempt. So that's just inheritance that tax. That's one tax to be concerned about. You're gonna say something, Will?
Yeah, because I didn't know this. So if somebody leaves a bank account to their best friend, 500,000, let's just say, for example, 500,000, whatever, and they are going to be taxed on that?
Yes.
What about life insurance too? Like
life insurance, I gotta look back at the statute. It's either exempt or exempt up to a certain amount.
Okay. That's a good question. You can get that answer.
So what we usually do is, that's why when we do this estate plan, we're thinking of everything.
Yeah, for
in
sure.
the universe, so I can make sure that it's going to work out to your benefit.
For sure.
But yeah, inheritance tax, you're only looking at that if you're going to give to certain individuals, and it's just based on relationship.
But I'm assuming best friends not common, but nieces and nephews seem like a common
Very common, very common. Yeah. So some people, like I said, they end up changing their mind. They're like, no, I'm gonna give to their mom or dad because that's my sister or brother, and they're exempt. So
That makes
they
sense.
end up switching it around. Some people are like, I'm giving straight directly to them for a reason. So if there's tax,
right.
you know, and some people are the mindset, I'm gonna be gone. They wouldn't get anything other than me dying.
And then how this is checked by the register of wills. I mean, like, so
yes,
they okay.
Honesty.
Yeah,
It's the honesty test. You know, they're gonna ask. There's a
who
form.
Who are they asking?
The personal representative of the estate has to fill out a form.
Oh, okay.
About what they know of as far as who is getting what from this person.
But the bank isn't reported or nothing like that. It's just an honesty thing. I'm just
yes.
Okay, got it.
Yes.
Okay, cool.
Yeah.
All right. Well, you
so that's one tax. So I always tell people, because people always worry about taxes, and some people it doesn't even, they're not even in the size of the estate to worry about it. So there is estate taxes in the state of Maryland. If you're at 5.43 something or 5.5 something, whatever the amount is above 5 million. If you are above that amount, that threshold, then your estate may be subject to inheritance tax.
Meaning your kids. Meaning
whoever is their personal representative of your estate, they will assist with determining whether an estate tax return is necessary to be filed and where the taxes will come from. Any liabilities or penalties from the tax will come from. And then during our lifetime, we pay individual income tax return. If you pass away and your estate ends up earning income, like you could have stocks, investments, anything like that. If they end up getting income through dividends or interest, depending on how much, then your estate has to file income tax return too. People always have this question about taxes or concerns about taxes. Again, when we go through an estate planning consultation, I'll look at everything that you have, figure out what you'll be subjected to. But again, we can't foresee the future. We can only talk about what you have right now and plan for right now. And if you end up getting more assets in the future, we can always revisit and see if we need to plan for estate taxes at some point.
Monica says, do you have to request an estate to be open, or does the probate office determine it when you file the will after your family member passes?
No. So this is what happens. When someone passes away, you file your last will and testament, but you have to indicate when you're filing it whether there's a reason to open an estate. Some people are filing their will just because they don't really have anything other than having the original will, and they want to make sure it's filed for safekeeping purposes in case something ends up coming up in the future. Say you find out there was a check that wasn't cashed for $500,000. You want to make sure that the original will has already been filed, so you don't worry about if it gets lost. So there's that. Then there is, if you know already when that person has passed away, that there are assets in that person's name, and there are no beneficial designation, then there's going to be an estate that needs to be opened up. It's up to you to determine what type of estate to open up. If you don't know, yes, you can ask the Register of Wills, depending on in your jurisdiction, if they will answer that question. Every Register of Wills is different. A lot of them like to lean on, we are not attorneys, so we can't give you legal advice. But they will send you forms to fill out. And so if there's a question of whether you really need an attorney or not, and you can absolutely give us a call. I am of the position that I'm going to tell you if you really need an attorney or not. Sometimes it's not worth hiring an attorney depending on what's there, because attorneys can eat up fees depending on how much you're standing to inherit. We do estate administration assistance for personal representatives depending on what they need. So some people may need me just to file the initial paperwork, get the estate open, and they can take it from there. Some people are like, Nicole, I'm not quite sure what I'm doing. So if you could stay on for a little bit, give me advice. We only do as much as the client needs us to do. So if you're in a position where someone has passed away and you do need to open up an estate and you're not quite sure what you're supposed to do, I always say, even if it's paying for the consultation so that you can seek advice as to what the process is, and you should do that. Okay. As far as attorney's fees goes, attorneys can get paid from the estate depending on the type of estate, or obviously the person who's coming in for the consultation can pay out of their own pocket.
Okay. Monica, who asked that that question, has some more specific information, but I prefer y'all talk about that offline. You know,
Sure.
and she said she would like to anyway, so I'll make sure that happens. Ida had another question. Oh, Ida, before I answer your question, I'm gonna ask another question. Does the individual? This is from Miss Mac, C Mac. Cassandra, is that you? I don't know. Does the individual or trust get the benefit if property taxes or loan taxes are on the house? Did I answer that question? Whoever asked that question, did I answer that right? Could you ask it audibly so it's clearly understood?
Yes. Does the individual or the trust itself get the tax benefit of the property? I guess the property of interest.
During the lifetime of the individuals, well, let's put it like this. Okay, so it depends on the type of trust, okay? Because some people have a trust where there are joint trustees, like say my husband and I have a trust agreement together, then my trust entity gets the benefit of whatever it owns, whatever assets gain income from that trust. If it's just my trust as a single person, then I'm using it as if I'm using it during my lifetime with anything else. So then I would get the benefit.
Well, it's mother-daughter. Daughter is the owner of everything. Mother would get the benefit of the trust. It's not a husband, wife. Single.
Let's talk about that offline.
For sure.
I need to. That's a question where I need to see the trust agreement, and that may also be a CPA question. So
thank you.
Even though we deal with taxes, sometimes there are instances where I know right off the bat where the tax is going to go, and there's some instances where I say I may know, but I'm not quite sure, and then I pawn it off to your CPA because that's what they do.
If you have any questions, just unmute yourself and ask real quick. All right.
I have one. If I have 4 children, and I know each one of them's personality, the one that I want put in charge of everything, is it best to leave him in charge or have a third non-interested party? Or, you know what I'm saying?
Okay, I do. I always encourage that you have a personal representative who is also going to gain from getting inheritance, because there's a reason for them to actually want to do it. If you want to name a third party who's not getting anything out of it, you can. You have to know that being a personal representative is like a job in and of itself. So that person could also charge the estate for their time. And when I say charge the estate, I mean that, you know, I always say if you want to be compensated for the work that you've done, I need to, from an attorney, I'm like, well, how much do you make right now at your job? If that sounds like a reasonable, you know, per hour fee, you got to give me itemization of the things you're doing. I drove to the house to make sure I met with the person to cut the lawn. I did X, I did Y, I met with the attorney. You know, you have to give me itemization. But I always suggest having someone who's going to benefit from it be named. However, only you know whether that makes sense for your estate plan, because that also means that the beneficiaries would lean on that person as far as communication. So some people who choose not to get an attorney involved to help them, they're that point person. Some people don't like to be in that position. They don't want to get calls, when am I getting my money? What's going on? They don't want to be that person. So they end up hiring an attorney to help, which is fine. That's what we do. However, you know, if you only know the parties involved to make that decision, but there's nothing wrong. There's no right or wrong in that decision either.
Okay, so can I just have it to where only one person knows what the others are getting? No.
So when you pass away, your last will and testament is public. Just so everybody knows, it's public. If you decide to get a revocable living trust, that is not public.
Okay.
But the beneficiaries that are named in this document are entitled to a copy of the document if they request it.
Okay.
Like, you can't have the 8 ball on me. If I'm supposed to get a certain amount, I need to see that I'm supposed to get it. How am I supposed to know if that's right? You could be trying to lowball me. How am I supposed to know that?
Okay, I was thinking that way because it would be my assets, my money. So I mean, they get what they get.
Or say when someone passes away, they're gonna get whatever's there. You could say in there, I want to give them $1 million, and if I ain't got it right now, or I ain't got it when I pass away, they ain't getting it. So I mean, put whatever you feel
Okay.
like is the right thing, but they're only gonna get what you have.
Gotcha. Okay.
You know, there's
Thank you.
nothing to that.
Yeah, that's right.
You know, and I tell people, don't overthink it. That is the misconception of estate planning. There's this like overthinking process that goes on with clients that either prevents them from coming into the office of the consultation or prevents them to getting documents signed so we can help. My job is to make it easier. I've seen the good, the bad, the ugly. I'll give you some examples of what ugly looks like, but that's what I do.
What does ugly look like?
Yeah, ugly. Let me see. My worst incident, quote unquote, and in a state administration, I represented a personal representative in a state, and one of the there are many beneficiaries. There was no last will and testament, and so one of the beneficiaries was under the belief that the property that he or she lived in was going to be theirs because they lived in it. That's not the case. If there are more than one beneficiary and you don't have a will that says I want to give it to X person, that means it's going to be split amongst everybody. So the whole like, oh, my mom or dad told me I was going to get it.
That don't work?
No, doesn't work. And so they were very unhappy. Unhappy to the extent that there were a lot of suspect behavior, a lot of threats, which resulted in a protective order. And so you'd be surprised how emotionally draining the process can be for everyone involved when you don't plan ahead.
Right.
Okay.
Right.
So that's my worst. My worst was that, I mean, we did what we had to do just to safeguard ourselves in case something actually did happen. But it's not something that, I look forward to doing ever again. I also had an estate administration where, this comes up more often than not, where you have family members, again, that think that it's more to it, that they're missing something, that there's money out there and someone's hiding it from them. The emotional aspect of the bickering between beneficiaries is what drives attorney's fees.
Got
so,
Just keep it in the buck.
Yeah, I mean, I'm a straight shooter. So when I represent any clients, and anyone who calls who is not a client of mine, my goal is there's no reason for me to hide anything from you. I'm not getting anything out of it. I'm not inheriting.
Right.
So there's no fight in the game. And at the end of the day, my job is to make sure that we facilitate the estate as the law requires and any documentation. But a lot of the issues in an estate administration where I get involved in is mostly a miscommunication because it's either no documents or documents are confusing. Or the documents are not confusing and it says exactly what it says, but because people don't get along with each other, they can't communicate with each other.
Right.
So, there are a lot of reasons why attorneys get involved. But my biggest one was definitely the protective order of case by far.
Is there any other, Christy, you have a question?
So, Nicole, I heard you say that you practice in Maryland. Do you legally practice in the state of Virginia?
I do not. If you live in any state outside or jurisdiction outside of District of Columbia and Maryland, you have to seek an estate planning attorney in that jurisdiction.
Well, can you please recommend one for me, because I do need to seek some estate counseling.
Sure, I would encourage you when this is all wrapped up, will provide my contact info. So please email me. I'm not gonna remember. Please email
Yes.
me, and then I will get some details as to where exactly you live in Virginia, and then I can forward you some info. Now, whoever I refer you to, this caveat to everybody who is gonna ask me for somebody else, for an attorney somewhere else. I am recommending people that have been recommended to me through other attorneys. I have not used any of them. I do not know what their fees are or their service is like. So if you have feedback and you want to say, hey, Nicole, that recommendation was great, more than welcome to let me know. If you say, Nicole, why the hell did you send me to this person? Just know I don't know them either. I'm just sending you things that at least I can get some type of info ahead of time from another attorney who's referred to them. Other than that, that's all I got for you.
Understood, Nicole. I appreciate it.
And
No problem.
And real quick, while we here, Nicole, if you could provide your contact information, you could put it in the chat.
Okay, yes.
Also, yeah, if you put it in the chat and then also give people your phone number.
Sure, I'll put my information in the chat now. Best way to reach me is by email. Everyone is working from home, so bear with us on getting back to you. And I'm giving you my direct line, so you don't have to go through anybody. Okay.
Cool.
So when it comes to consultations, right now we're doing everything virtually. So it'll either be a telephone conference, or if someone likes to do video conference, I'm more than open to do that as well. We walk through documentation with you that you would have already received via email prior to, or mail, whichever you preferred. The only time you end up seeing me is when we actually sign documents, because everyone wants to be safe during COVID. So you will not see me for the signing appointment.
Okay, cool. And I'll post your info again in the email and in the group. John Johnson has another question. He says he's an unmarried, I'm assuming he's an unmarried homeowner with a living fiance. What dangers am I heading toward if I pass away prior to marriage, if I have a will or if I don't have a will?
Oh my gosh, that's a great question. I'm so glad you asked me that. I actually have an estate with that going on right now. Okay, she's your fiance, so she's your friend. Okay. By law, she has no relationship to you at all.
Or he, you gotta be.
Or he, I'm sorry, or he. My apologies ahead of time.
Yeah.
Or he is a friend.
Okay, all right,
So,
John Johnson's a her. Okay, cool. I just been burned a lot of times with that one. But
okay, yeah. So I learn something new every day. So thank you, because I'm so used to,
Yeah.
I got you. Thank you. So that individual is a friend by law,
Okay.
which means that if they are not on the title to anything, then they are not entitled to anything. Okay. If you were to pass away, then we look to, it would depend on if you're a Maryland or a DC resident, but we look to parents. You said no children, right?
He said Maryland. He didn't say anything about children. Any children? John, you can speak up.
Okay, no, I see no children.
Okay.
So we look to parents, we would look to siblings, we look elsewhere. But no, that individual would not be receiving inheritance unless they are designated by beneficiary designation to receive any inheritance from you, and or are named on the tiling of any accounts.
So you're saying, okay, hopefully you guys can hear me. So, all right, so a will makes no difference then, is what you're saying?
No, will makes a difference.
Okay, so the will does make a difference.
Yeah.
I can name them.
Unless you name her to get anything. And the only way you could do that is your will or trust.
Will trust or have her name on beneficiary type of 401ks or life insurance type of things.
Whatever. So,
okay.
and so let me caveat this, okay? Because there's a belief that you can name a beneficiary on everything. You probably can for the most part. But in case there are things that are missed, that's the point of getting a will. The point of getting a will is that you don't have to make sure that everything is designated everywhere, because people miss stuff all the time. And your will is an overall document. Anything that comes in when I pass away is going to go to this person wherever it's located. So I would suggest that you review the beneficiary designations that you have. If you want her to be named on those beneficiary designations, you should do that. but also you should get a will in case there's something that you miss.
It seemed like I just heard will trumps whosever name is on the beneficiary documents that I may have done 10 years ago.
It does not. It doesn't trump, but it can be used together. The reason why you get a last one testament is in the event you have assets that have no beneficiary designated because you forgot to do it.
Gotcha.
Or you have assets for which it's not titled in her name, it's just in your name, and again, no beneficiary designation. Okay. So that's the purpose of a will. Let's say you passed away and you didn't get your last paycheck. Right? What ends up happening is your job is going to have a check that's owed to you, but you're gone. That check would then be part of your estate. The check has no beneficiary designation. Come for your job, it's a check. So your will, if you have one, would say, this check is supposed to go to my fiance because you have a will. You understand what I'm saying?
100%. Thank you very much.
Yeah, the will is not to, you're not looking at a estate plan to say, I should have a beneficiary designation or a will. You should always have a will. If you end up designating your beneficiary, that's an extra bonus, but you should always have a will just in case.
Thank you.
Sure.
John, is that everything you need right there, brother?
100%.
All right, cool. Miss Mack has another question. We have your hand raised. Is the question you have in the chat the question you have, or did you want to ask another question?
No, I wanted to ask another question since she only practices in Maryland.
Sure.
Since she only practices in Maryland, and I live in Maryland currently, I've been here for 20 years, but if I start the process with you and for whatever reason I move away and I pass away in another state, is everything still valid that I start with you here and I'm going to live for another 60 some odd years?
Okay, so first I practice in Maryland and DC. So if anyone is in DC, I can assist you as well. Second, if you obtain estate planning documents in either Maryland or DC and I've drafted them for you and you move somewhere else, they're still valid no matter where you move to.
Great question.
You should speak with an estate planning attorney in whatever the new state that you move to is, just to make sure that they have put their eyes on your documents in case there are some laws there that may affect the options or information that we put into your document. So let's say, for example, here, you know how we have inheritance tax, we just talked about, I want to give to my niece, they're, taxed 10%. But I said, I don't want to give it to her, let me give it to my brother because that's a freebie. Right? If you move to Florida, they may not have inheritance tax. You may then be able to give to your niece with no problem. You may want to change it. So yes, your documents will be valid. You should always speak to an estate planning attorney in the new state just to make sure that if you were to pass away there's nothing that you don't need to be worried about if you want to change anything in it. If you were to move to a new state and you died in that new state, I wouldn't assist you with your estate plan, your estate administration, because I'm not barred there. But it doesn't mean your documents are invalid.
And I know it's not a simple process, which was why I had my other question. I have 3 children. I wanted to divide everything a third before they started having children. So.
Okay, let me go back. When you say I want to divide everything a third, what do you mean? Are you saying that you're now, tell me what that means.
So everything that I have now, the value of the home, my TSP, whatever's left of it, any monies that I have from any Roth plans I have, everything was initially divided a third. Okay. Now I have grandkids. So things aren't that simple. When you give your consultation, do you consult across every aspect of the changes in life?
Yes. You'd be surprised the stuff that we talk about in our estate planning consultations. Like I said, there are always someone you don't want to get something. There's always a concern with either a beneficiary or a family member. So we go through everything. We look at your beneficiary designations. It's like a brainstorming. So you can tell me what your concerns are, tell me what you're trying to do, and I can advise on the best way to execute that plan.
Thank you. Just listening to your call now has me thinking that, my simple oh, everything will be fine because I'll divide everything a third. Now I'm listening to you and some other questions people have had. And even though I'm single and I have 3 kids I love dearly, I want everything divided evenly among them. They have kids now.
Yeah, we plan for the future too. So we can talk about that in our estate plan. You know, like I said, the purpose of going to an attorney is I'm thinking ahead of you. You're on this and I'm already past that. So my job is to make sure that when we prepare anything for you, that you don't have to worry about anything. So we can definitely go through all of that and how the grandkids fit in and all that good stuff.
Got it.
Awesome. Thank you so much.
No problem.
John, did you have something you want to add?
Yeah, thank you very much. Well, when she mentioned about living in other states, so is that like the rule of thumb? I mean, of course, every state has its own laws or whatever. So the law is pertaining to the state that I currently live in and not where the beneficiary lives. Is that
exactly? So when you pass away, the laws that end up overseeing your estate administration is the state for where you passed away at. So if you died in the state of Maryland, you were a state of Maryland resident at that time, then Maryland laws will apply to your state administration. That's if, even though your will was drafted in California, makes no difference. You died as a Maryland resident. And it doesn't matter if your beneficiaries live in Montana. I've actually represented personal representatives that lived out of state, beneficiaries that lived out of state. As long as the person who passed away lived in Maryland, I can handle their estate. I've had beneficiaries and personal representatives. I had them in Kuwait, London, all over the world. Kuwait was a funny thing. Getting the mail is a whole different world out there. But yeah, they can live wherever they want to live. But the person who passed away has to have lived in the jurisdiction for where I practice, which is Maryland or DC, for me to get involved.
Got it. Is there any other questions before we let Nicole go?
I do have one scenario that hasn't come up yet, but I think it's important because I think this type of couple may overlook it. Okay. Is if you are a blended family, meaning you are married to someone and you guys do not share the same children, I'm gonna need y'all to also come in. Okay, because a lot of those individuals plan as if they are sharing the same children, and you overlook a lot.
I could imagine.
A lot. So we need to have that conversation as well.
I could imagine that. Yeah, for sure. Is there any other questions before we let Nicole go? If so, just unmute yourself and ask. But yeah, Nicole, this has been valuable. I've been getting so many DMs on here talking about, is this going to be recorded? Can you please send me this? Can you please send me this? So yeah, we should probably do this once a quarter for certain. You know,
I always say I have tons of knowledge to share. Look, my go-to is, it's not about the decision that you make, but it's that you make an informed decision.
Sure.
And so a lot of people walk around assuming that they think they know what's going to happen when they pass away, if they have a will, if they don't have a will. If you don't know, then you need to come in. Unless you're an attorney, you don't know. Right. I'm just, go ahead. I don't care how many people have passed away that you know of and you've heard all these things, you really don't know. The consultations are free. Okay, so come in, let me take a look at what you got, and then let me tell you what you should or should not do, or what my advice would be. And again, some people come in and they're like, give me the most expensive thing, and I can talk them down. My job is to provide good service. Right. I always tell people, I'll take your money. You don't need to pay it to me, but I'll take it. But if I don't feel like you need it, I'm going to tell you that. That's my job, and that's how I get good business.
Yeah, and Nicole's been taking care of our clients for years, and her prices are good. So, and obviously her knowledge is good too. And you're either gonna give the money to her or the court. So, you know what I'm saying? So,
I'm just so glad that you wrote it.
Well, some other scrupulous attorney that's playing on your kids' emotions. So you might as well just get that stuff done for real.
And look, I'll either get it now at a cheaper rate, or if you come find me later and it's higher, then, I never want to say to somebody, I know you say, oh, I wish you would have came in, but I can't tell you how many times I get kids that call me and it's too late for me to help their parents. Yeah. They're like, oh, I'm trying to do estate planning because they know how important it is.
Yeah.
but their parents didn't realize how important it was. And when it comes to estate planning, we can only prepare documents to the extent that that person has an understanding of what they're doing. Once we start talking about elderly health issues, there could be an instance where I cannot help you, and it's happened a lot. And so I want to make sure that whether it's you or your parents,
That's
that
actually a
everybody
really
has their
good point.
documents together.
So that's a really good point. So you mean to say if somebody's 90 something years old, they don't have an estate plan, and it's just looking bleak. They can't sit down now at 90 years old and write an estate plan if they're not fully functioning. Fully functioning. Is that what you
And
mean?
when I say fully functional, I mean here.
Yeah,
I
for
don't
sure.
mean physically. I mean the inability to ascertain what they have.
Yeah.
Be able, I'm talking to clients by themselves. As much as kids want to come in and say, "Hey, I want to help my dad. I'm gonna need you to step outside. Let me talk to your dad for a second. Let me make sure that you're not like, hey, nudge, nudge. Give me everything."
Pigeon is style.
And so, my job is to make sure they understand. So I've had instances where I'm like, this person does not understand. And some kids will tell me up front, look, my dad has dementia, Alzheimer's, or they're like, they forget a lot. Then I can't do anything to help you. There's nothing that I can do.
Yeah.
There's no attorney that's going to do it either.
Right.
So if your parents do not have an estate plan, and if you think about it this way, the estate plan is not for you. Okay. As much as it's important that you do it, the purpose of you doing it is for your beneficiaries. It's for your family. So if you're looking to, I want to protect my family, I want to protect my assets from them having to pay all this money to somebody because they don't know what's going on, get the documents done. To save yourself a headache for your parents, get them in so they can get the documents done.
Right. Okay. All right, y'all. Well, Nicole's information is here. I'm going to post it in the group. Nicole, I appreciate your time. Yeah.
Well, if anyone has any questions, you know where to find me. Again, consultations are free. If there is, some parents have a hard time grasping that they need to get it done. If you feel like you want to have a kumbaya moment and you want to call them with me or something like that, we can schedule that to happen. And there are many ways that I've talked to elderly individuals about the importance of this stuff. And again, my job is to make it easier. So maybe if they need that conversation to help them get over the hump and get it done, I can absolutely help as well.
Awesome.
Thank you guys for having
me.
me.
Have a great evening and go George Floyd. Talk to y'all later. Bye-bye.